which was number 5. Number 4 was deferred and basically sent back to the back. I hope that's not an ominous. Number 4 was we deferred. And you'll remember the most recently we were deferred that was at our meeting on March the 20th. The State Public Defender's Compensation Plan has been considered. This would be the 4th time, if that's why it's on the agenda. It was referred to the committee back in June at the first meeting we had. The committee made a recommendation to reject that and made their recommendation. The recommendation of that committee was adopted at the October 16th meeting, which we rejected the compensation plan. And again, I have the transcript. I don't have any minutes, but I did get a transcript of our March meeting. And at that time, Mr. Starnes brought the compensation plan up again. And although it was acknowledged that we had rejected that twice before and once in the committee, that the recommendation was made to refer that back to the committee to the extent there was any new information in that plan. None had been provided prior to last Friday. And I assume everybody received, I got an email from one of the chiefs, I think it's Maggie LeBlanc, which was a sort of an endorsement of the plan. And that's something that, as far as I can tell, these 2 items, number 6 under old business, are still in the committee. We didn't have any new information until last Friday. And I would suggest that based on that and make a motion that the committee would meet again to consider that as well as any changes. I'm not aware of any new information in the compensation plan that hasn't already been voted on and rejected. But if there is, we'd certainly want to consider that. But more importantly, I think we would want to get input from these chiefs who initially opposed that plan and now, as of last Friday, appear to be endorsing that plan. We would want to talk with them and say, what has changed? Are there different components? Is your view different? I think we would need that and let that committee then make a recommendation back to the board as to how that would affect the recommendation of the committee, if it would change. And perhaps we should either have a hybrid or we should recommend Mr. Starnes' committee. But either way, those 2 items are still in the committee and they've not been reported out of the committee. So my motion would be to remove those from the agenda, refer them back to the committee for consideration so that the committee, which has met pretty timely in the past, could make its recommendation at the next board meeting. That's my recommendation. And
so you have a substitute motion to remove from the agenda items 6A and B?
Yes, sir.
And refer that to the compensation committee to consider any new information, including but not limited to the most recent letter received by all of us from, I don't know, 20 some odd.
Yes, sir.
District defenders.
And to be able to let them have an opportunity to talk with us about that. Technically, I think these 2 are still in the committee and haven't been reported out. But yes, sir, you've more articulately than I have stated the motion.
All right. Do we have a second to the substitute motion?
A second.
All right. We'll vote on the substitute motion first. Is there any discussion relative to the substitute motion by any of the members from the staff? If not, let's vote on the substitute motion, which is to send items 6A and B, which are currently on the agenda, to the compensation committee for consideration of whatever new information, including but not limited to the letter from the district defenders appearing to endorse the state defenders compensation plan. All right. Do we have any opposition to the substitute motion? Without any opposition, substitute motion passes.
Thank you, Mr. Chair. That's all I have.
Items 6A and B will be referred back to the compensation committee, who will then report back to the board at our next meeting. All right. Having dealt with that, let's go to vote on the original motion to adopt the agenda, but for removing items 6A and B. Any opposition to that motion? Hearing none, that motion passes. And the agenda as amended is now adopted. All right. Next up is item 3. We have 2 members who have resigned. Mr. Ted Hernandez, and Judge Freddie Pitcher. And they have since been replaced. And I would ask our new board members just to introduce themselves.
Hi there. So Jeff Huff, I'm an attorney out of the greater New Orleans area. Stephen Dwyer, likewise, I'm from the greater New Orleans area.
Welcome, gentlemen. All right. Next up is item 4, public comment. If there's anybody who has signed the sheet for public comment, it's up here, and we can see who we have signed up. We will limit public comment to 3 minutes. Just as a reminder, if you are to engage in public comment, it shall be limited to one of the items on the agenda. You will identify the item that you wish to speak on as you come up. We got a... Thank you, Judge.
Yes, sir.
Mr. Brett Brunson. Good morning, Mr. Brunson. What item are you speaking on?
Item 7.
All right. You may begin.
Do I need to hold down anything?
I wish I knew. There you go. It looks like you turned red.
Good morning. I'm Brett Brunson. I graduated from LSU Law School and have practiced law since 1979. In the 80s, I was a line public defender in Sabine, DeSoto, and Natchitoches parishes, and in the 1990s, I served as an assistant DA in Natchitoches. I've handled every kind of criminal case from both sides, most often second-degree murder trials. In 2007, I gave up a successful private practice, including general counsel work for 2 banks, when the Indigent Defender Board recruited me to be the first chief public defender for Natchitoches Parish, and I've held that role ever since. Over the past 18 years, under 5 different state public defenders, I have never faced any disciplinary issue or administrative complaint. In fact, my office has often been called a model program. I've been asked to help train others across the state. I've also served on both the first and last district defender advisory committees. So let me be clear, my termination in item 7 was not done in good faith, and it was not for good cause. It was retaliation, plain and simple. First, retaliation for my testimony before the House Criminal Justice Committee in February of 2024, where I opposed Senate Bill 8, which abolished the Louisiana Public Defender Board. Second, for standing up to Mr. Starnes when I witnessed his pattern of bullying and mistreating women. When I learned that he planned to use a statewide survey as a pretext to, quote, get rid of those 3 women, close quote, I knew who he meant. He meant Chanel Long, who was terminated in 2023. He met Michelle Andrepont, and Tricia Ward, both of whom are here with me today and will speak following my talk. I immediately called my friend Deidre Fuller, who was also here with us, and we agreed to notify these women of what was said and bring our concerns to the board members. And on November 8th of 2022, I directly told Mr. Starnes that his targeting of women was unacceptable and that we expected civil treatment for all district offenders. Finally, I believe I was fired for telling this board the truth, that Mr. Starnes' compensation plan would have cut my pay by $40,000. The 5 of us who are about to speak, the other 4, are each experienced ethical trial lawyers, and we have this in common. We told the truth to this board and the legislature. We followed the law. We acted in good faith at all times, and we opposed bad behavior and bad policy. Thank you.
Thank you. Well, if I can make it stop. All right, next is Michelle Andrepont. Ms. Andropol.
Good morning, Mr. Chairman, members of the board. My name is Michelle Andropol. I have served the people of Caddo Parish as a public defender since 1994 and as district public defender since 2020. I've dedicated over 30 years of my life to this office and to the constitutional right to defense. I've never received the negative performance review, and my contract has been renewed every year without incident. Notably, because of my leadership, I secured $250,000 in line item funding for the Caddo Parish Commission for the first time in the history of the office. Yet, despite my record, I received a one-sentence letter on February 27th of this year notifying me that I was being terminated effective June 30th. I got no explanation, no performance concerns, and no cause. I was not alone. Myself and the 4 other district defenders with a combined total of nearly 115 years of public defense experience are being terminated, each of us having publicly challenged policies and proposals advanced by the state public defender, Mr. Storms. We all received identical letters, all without cause, all without justification. We weren't surprised. We had already warned the legislature that this exact scenario could happen, and now it has. So let me be clear. My termination is not just unwarranted, it's retaliatory. It's my punishment for speaking out, and is at least in part because I'm a woman. Under Mr. Storms' leadership, there have been a troubling and consistent pattern of disparate treatment of women. There have been, yes, these dots indicate district public defenders. The pink and red ones indicate females. Of the district defenders being terminated this year, 6 are being terminated this year, 4 are women. Of the 8 total that Mr. Starnes has failed to renew or recommended that not be renewed, 6 of those are women and 4 of those are black women. The only 2 men being removed are the 2 men who have stood with us as women. This is not coincidence, it's systemic. This is not the first time Mr. Starnes has attempted to consolidate power to himself. This past legislative session was the 3rd time in 5 years that he's been the state public defender, that he's gone to the legislature to ask for more control over the public defense system. I testified against each and every one of these attempts because I believe in the independence of the public defense system, I believe in accountability, and I believe in justice. The legislature, hearing our concerns, enacted laws to protect us. They gave us the continuity under 161H1, which says that the district defender shall continue to serve as and shall continue to contract with the state public defender. They also gave this oversight board the authority over our compensation in 161H2.
Thank you, ma'am. Your time's up.
I have copies of these for everybody, if I may.
You may. Next is Ms. Tricia Ward. Thank you. I'm sorry. Thank you, Tricia. Good morning, Ms. Ward.
Good morning, members of the board. My name is Tricia Ward. I've been a public defender since 2008, and I've served as district defender in the 13th Judicial District since 2021, when I was hired by unanimous vote of the Louisiana Public Defender Board. I've had 0 performance issues. In fact, a site visit report from the State Public Defender's Office noted, quote, "Ms. Ward has improved the quality of representation in the 13th Public Defender's Office," end quote. And yet, in February of this year, I received a one-sentence letter from Mr. Starnes terminating my contract effective June 30th. That decision was not made in good faith. I believe it was, at least in part, a response to my exercise of rights that are both legal and protected. I've taken time to offer input before the legislature on important issues impacting public defense. I've reported to this board as required by the statute. I've asked questions, hard questions, about fairness and equity. This pattern of retaliation didn't begin with the letter I received in February. Since becoming state public defender, Mr. Starnes has initiated peer reviews in only 2 district offices. Both were led by women. Mine was one of them. Then the day after Mr. Brunson told you that he asked Mr. Starnes to stop bullying women and to treat us all with civility, Mr. Starnes met with the legislative auditor. Within a month, the auditor's fraud division showed up at my door. 2 other offices were investigated, both also led by women. The input I and others have given to the legislature has made a difference. In 2024, Mr. Starnes proposed removing all of your power. The legislature rejected that. It created an oversight board, this board, to provide supervision and oversight to the Office of the State Public Defender. Mr. Starnes wanted just an advisory board. And most importantly, this board, not Mr. Starnes, is the final authority on whether a termination was made in good faith with just cause. Today, he wants you to believe that non-renewals are exempt from that standard, that the legislature didn't intend for just cause to apply when a contract simply ends. But that's not what the law says, and it's not even what he told the legislature. In 2024, when advocating for the bill that became the current law, Mr. Starnes testified, quote, "There are roles for the Public Defender Board in Senate Bill 8, particularly in regards to when contracts are not renewed," end quote. That was his testimony. That's what he said. He knew then what he's trying to deny now. Last month, Representative Bacala specifically stated that contract non-renewals was subject to board review. He even noted that you were all engaged in that process right now. Everyone in this room knows that just cause does not exist for Mr. Starnes' actions, so I'm asking you, I'm imploring you to do what the law empowers and requires you to do. Exercise your oversight, hold Mr. Starnes accountable, and make sure the law is designed to protect Louisiana's public defense system and the people who serve it are respected and enforced. Thank you.
Thank you, ma'am. Your time is up. Next is Deidre Fuller.
Good morning.
Good morning, Ms. Fuller.
My name is Deirdre Fuller. I earned a dual degree, a JD and an MBA in management from Loyola School of Law and Loyola University, respectively, in 1995. I practiced for several years before joining the Public Defender's Office. After serving as a felony line defender for 6 years, then Chief Judge Patricia Cook, someone whom I deeply respect, encouraged me to apply for Chief Public Defender in Rapides Parish. She told me plainly that I was the best person for the job. In 2016, I was selected. I became the first African-American female chief defender in the state of Louisiana, and I'm the first woman to hold that position in Rapides Parish. 9 years as a chief, I've never had a single disciplinary issue. No complaints tied to my job performance. What I did do, I worked to elevate the system, building relationships, sharing resources, and inviting subject matter experts like an employment lawyer to offer free training to other chiefs because I believe in collaboration. So why am I terminated? Not for misconduct, not for mismanagement, not for poor performance. In my view, I was terminated for choosing to participate in the legislative process on numerous occasions and to testify before the House Administration of Criminal Justice Committee in February 2024 in opposition to Senate Bill 8, the bill that abolished the prior board. I was terminated for standing up, standing with, and not standing for the ill treatment of my colleagues. In my opinion, my termination lacks any just cause or good faith rationale. I believe it was retaliatory, and I am not alone. Those of us who have become known as the DD5 share one thing in common. We refuse to be morally complicit. We refuse to stand silent when the state public defender acted unprofessionally toward our colleagues. We refuse to enable attempts to sidestep the law and this board. And we refuse to retreat when we were punished for doing what was right. We are not discouraged. We're not disheartened. We acted with character. We acted with courage, and we still believe in this work. Personally, I am 1 year from vesting in my parochial retirement system in my office. My plan was to enter the drop program and retire with dignity after a lifetime of public service. Instead, my reward is termination. This is not just unfair, it is wrong. Thank you for listening.
Thank you, ma'am. Next is John Hogue.
Yes. Good morning, Mr. Chair and distinguished members of the committee. My name is John Hogue. I'm a proud graduate of Loyola Law School. I've dedicated over 27 years to public defense. Like my colleagues, I too received a one-sentence termination letter without cause, without explanation, because no just cause exists. So ask yourself, why are 5 district defenders with a combined almost 115 years of service really being terminated by Mr. Starnes? Since he won't say, I'll offer you 3 reasons. First, I believe we're being terminated for our involvement during the 2024 special legislative session, which considered Senate Bill 8. The original version of the bill eliminated the Public Defender Board and granted unchecked authority to the state public defender, a version Remy Starnes supported. Thanks in part to our advocacy, the legislature amended SB 8. They maintained limited board oversight, ensured due process for district defender terminations, and protected the continuity of public defender services, requiring just cause for removal. Second, I believe I'm being terminated for opposing Starnes' compensation plan. I testified before this board, right beside Mr. Starnes, and warned of the damage his plan would cause to my rural poor district. Your role is oversight, and you deserve honest feedback. You listened and wisely rejected that plan. Now, some of us are paying the price for speaking truth to this committee. Third, I stood by my female colleagues who feared that they were being unfairly targeted by Mr. Starnes. As the father of 3 daughters, I hope that their workplaces will value fairness and courage too. Supporting them was simply the right thing to do. In closing, this board represents the people of Louisiana. What you decide today will be seen by our communities, by our profession, and by history. Will you allow defenders to be silenced for speaking out to the legislature, for giving honest feedback, for standing up against workplace inequity? I urge you, fulfill your duty, exercise your oversight. Reject the fiction that these are routine contract non-renewals. They are not. This is termination without just cause. This is retaliation. Please, please, do not be complicit in this injustice. Thank you.
Next is Ross Foote. A letter to be read.
Yeah, Mr. Chair, I know we have a lot on the agenda. I'm not going to read this letter, but as you may know, Judge Foote is a retired state district judge. His wife is a sitting federal judge in the Western District of Louisiana. Judge Foote could not be here, but he asked that I read this, but because we're short on time, I'll just hand out a copy of his email. It deals with his interactions with Mr. Starnes, dealing with some of these same individuals, and the reason for his resignation from this board just prior to it being abolished, the prior board, prior to it being abolished. I'll just hand out a copy. I don't want to take everyone's time by reading it into the record.
All right.
We can all read.
Next is Jean Faria. If I'm pronouncing that correctly.
I don't want to interrupt her.
That's all right. We'll let you finish before she starts.
Good morning, Mr. Chairman, members of the committee. My name is Jean Faria. I was the first state public defender under Act 307 of 2007, and I want to give you a little bit of background about the contracts and where they came from and how they were used. In the beginning, there were no contracts, as you all know. The judges all know that the local judges appointed indigent defender boards in each of the judicial districts. And with the abolition of those boards, all of those chief defenders, now called district defenders, were grandfathered in. The district defenders maintained their positions for years without contracts. And after a few years, it became clear that many of the district defenders were not following their statutorily mandated duties, and to be fair, the level of oversight was entirely new to the district defenders. To address the problem, the board authorized me and my general counsel to develop a contract which outlined the statutory duties of the district defenders. There was no evergreen provision in the contract because there was a priority placed on continuity of leadership in those offices, and the grandfather clause. The intent was clearly to articulate to the district defenders their duties and to annually remind them of those duties. In my tenure as the state public defender, there was never an involuntary non-renewal of a defender's contract without cause. That never happened. What you are seeing here is not the original intent of the contracts. The role of this board is to oversee the work of the state public defender. The board's role is essential to determine whether the state public defender is performing statutorily mandated duties appropriately in the best interest of the clients and according to best practices. To date, the current state public defender, as you have heard, has terminated 6 of 11 women over the last 3 years. 4 of them are black women. Only 2 men who have no performance issues have been denied a contract for no cause. They simply supported the 3 women before you today. In order to properly supervise the state public defender and demonstrate to the district defenders what to do and what not to do, a for-cause hearing is essential. The message that this board will send to the district defenders is that there is, for any reason whatsoever, they can be terminated and no one will know. No one knows what was right or wrong in this process. This is not a contract issue. This is retaliation, pure and simple. Thank you.
Thank you. Next is Mr. Jim Boren.
Maybe swap. I'm Nathan Fennell. Mr. Boren wanted to swap out, but with me, just.
It's fine. Instead of Mr. Boren, it's Nathan Fennell. Hang on, let me turn this off and start anew. There we go. Good morning.
Good morning, Mr. Chair, members. My name is Nathan Fennell. I'm a staff attorney and primarily a litigator at the Deason Criminal Justice Reform Center, which is based at the SMU Dedman School of Law. This center has deep expertise in the Sixth Amendment right to counsel, and we particularly work in rural areas. If the state defender can remove district defenders without any oversight, then the Louisiana system will not meet national standards for public defense delivery. National standards call for a public defender to be independent of both political and judicial influence, and independence protects a client's right to conflict-free counsel. It also ensures that we have excellent, effective, and ethical lawyers doing a very hard and important job. If the state public defender can fire a district defender for doing their job too zealously, or for no reason at all, or potentially for an affirmatively bad reason, then it's going to be much harder to fill these roles with high quality and ethical lawyers. And that will be particularly true in the state's rural areas, which already have a lawyer shortage. If the state defender, whose job depends on a gubernatorial appointment, can fire district defenders at will, then district defenders can't practice without fear of reprisal. This includes in high-profile cases, in politically charged cases, and in pretty much any case that's initiated by the Louisiana State Police, which is run by the governor. Without good cause protections, district defenders can't provide the kind of zealous and independent representation required by the Sixth Amendment and national standards, and it would open the floodgates to post-conviction litigation. This is even more important in view of the state public defender's new contracts for district defenders, which are included in item 8 of the agenda. These contracts ignore state law and ignore this board. They purport to remove statutory good cause protections from removal in any context. They add a compensation plan that is different from what this board approved. It's frankly, for lack of a better word, disrespectful to state law and to the district defenders that do the work every day, and to this board. And it further highlights why you should exercise your oversight authority over every time the state defender attempts to remove a lawyer from their position. Finally, I want to speak about the proposed compensation plans that are in the district defender contracts that the state public defender produced, which are frankly both shocking and unconstitutional. The CUF provision specifically, it means that district defenders are personally compensated more when more of their clients are convicted. It is a conviction bonus for public defenders, or at worst, a conviction and collection bonus. The Fifth Circuit somewhat recently looked at a similar issue in Caliste versus Cantrell and found that a magistrate judge had an unconstitutional conflict of interest when the bail amounts that he set impacted the amount of money he had for office expenditures, not his personal salary, office expenditures. And the Fifth Circuit said that that was an unconstitutional conflict of interest.
Time is up, sir.
How much more so for public defenders in this instance? Thank you.
Thank you. Mr. Burrell? Mr. Bourne? Yes. Good morning, Mr. Bourne.
Good morning. My name is Jim Boren. I'm a lawyer in Baton Rouge, Louisiana. I'm the president of the Louisiana Association of Criminal Defense Lawyers, which is an organization formed in the 80s and consists of 350 to 400 criminal defense lawyers, public defenders, and private lawyers around the state. I also served on many iterations of the Louisiana Public Defender Board, including its very first one throughout almost all of their iterations. The 2024 special session changed things to form this board with oversight. The amendments curbed the power of the state public defender and shortened his term to 2 years. I believe the law is very clear that you will be asked to apply, and that is that 161H1 requires the state public defender to contract with the same district defenders. That was to provide continuity. There's also a cause hearing for non-voluntary terminations. According to Mr. Starnes' testimony himself on February the 20th of last year, that's what he said the rules were. The legislators expect that. The state public defender can't draft a contract that contradicts or circumvents the law. There is no termination for convenience. You can't fire somebody because they stood up to you or because you're a woman or both. District defenders can't waive their statutory right to appeal. The legislature has specifically rejected again this year the state public defender's effort to change the law to eliminate you altogether, and said the purpose of this board is to review and provide oversight of the state public defender, including such matters as the termination of the contracts, which is, you can call it whatever you want to, but if you've got 115 years of public defenders and they're all fired on the same day with a letter that says you're not being renewed, and the only thing they have in common is that either they are women, supported women, or that they have stood up to the public defender and said that these policies are wrong, that's simply wrong. And the last thing I want to say is, the legislature itself has recognized that there must be independence. The 10 commandments of the ABA said the very first thing about public defense is that it should be independent of all political influence. And if you have a state public defender appointed by the governor who can get rid of anybody who gets rid of him, who doesn't like him or votes against a rule, testifies against him, that is not an independent state public defender. What that is making the post-conviction lawyers of Louisiana salivate over the prospect of having the state public defender appointed by the governor, who is also seeking the death of their clients through that office. I urge you to renew these contracts of these defenders, and we all appreciate your attention and your time. Thank you.
Next is it Checo Yancey? Good morning, sir.
Good morning, sir. I'm not as eloquent as everyone else, and I'm probably not as important as everyone else. I'm just a citizen.
You're just as important as everybody else.
Well, that's what they say, but it doesn't seem like that since 2024 in the testimony of the public defenders. My name is Checo Yancey. I'm a former incarcerated person, and I work for the organization of Vote. And it seems here that Massa is really in charge. And he's got a whoop man that can whoop the underlings and make sure that they don't have a chance to do what they're supposed to do, and that's to defend people that cannot afford to have an attorney. Question is here, what's really going on with the indigent defendants these days? Consider that lawyers are supposed to work on behalf of their clients, and I've seen several years that the Indigent Defender Board people have come to the legislature and had opportunity to testify. But now that Massa is in charge, they can't, and they get fired. District attorneys testify all the time, and they are rewarded because they can get people more time. Several of the people that have spoken earlier this morning, I know them personally to be upstanding. They don't win all the time, but at least they fight for their clients. I'm going to urge you to really look at everything that's going on here. This board should be as active as the District Attorneys Association in putting bills and testifying about the criminal procedure that's going on. We just passed some of the most horriblest laws to make sure we lock up people and keep people locked up for years. We've taken away good time, parole eligibility. Now we've taken away the people that can help people that cannot afford an attorney. I urge you to really look at this situation and stand up and have a new day. We saw the Honorable Mr. Pitcher resign and say he just couldn't take this. I won't say the word that I'm thinking. He couldn't take it anymore. So I'm asking you to really listen at what the people that's professional, that can do the job, and give them an opportunity. Thank you. And don't listen to Massa.
Thank you, sir. All right. That's all of the public comment that was signed up for. So we'll now move to item number 7 on the agenda. Adoption of the hearing committee's report/findings and recommendations. I'll call upon the committee chair, which was Judge Paul DeMaillet, to address that item.
I'll move for adoption of the report. The report has been distributed. Switch that.
All right, I have a motion by Judge DeMaillet for the board to adopt the recommendation of the hearing committee's or their recommendation. Do I have a second?
I'll move to second it.
We have a second. Any discussion?
Before we begin, I want to make sure everybody has a copy of the 2 statutes that deal with this. It's 15-161 and 15-170. If they don't, I have copies for everyone so we can follow along, because this is a rather complicated issue that we've struggled with at our last meeting, and I want to just make sure everybody has a copy of it in front of them. So I'll pass that around. If you have one, fine, or if you know it by heart, that's fine too. And when we're ready for discussion.
We're ready for discussion.
We can't hear him.
You're on. This is what is being passed out.
I don't think I'm on.
Don't press nothing.
I'm not pressing anything.
Now you're on.
Hands up. Not behind my back, but hands up. I have a few questions before we begin. The opinion that we received, do we know what date that was rendered? It doesn't have a date on it. I was wondering if we knew.
I defer to Judge DeMaye,
Just for
who
timing.
chaired the committee. The date that it was rendered?
I don't recall.
Okay, because it's not dated, and I just want to make sure that as a board, we're complying with all the timing requirements, the 30 days, and so if we don't know, I know that when we received it, I believe it was outside the 30-day window, but that doesn't mean it wasn't rendered within the 30-day window. But if we don't know, Ms. Boutte, do you remember when it was rendered?
Trying to look it up right now for you.
Okay, thanks.
Okay, I think it was May the 20th of 2025.
Okay, and the hearing was on April the 7th. Does that sound right? I think that's what's in the report.
That's correct.
Okay. I believe under 170, Section 170, the report has to be submitted within 30 days of conducting the hearing, and that it has to include all submissions, which I don't believe we received, the findings of fact, which I would suggest are probably sufficient in the recommendation itself, and that notice of the submission be provided to all parties, which I think we subsequently learned it wasn't at the time provided to all parties. Additionally, we learned that we received an email dated May 1st of 2025 from the Office of the Public Defender with additional information that was directed to the committee, which all the board members received, which I understand in the recent filings was not provided to opposing counsel. This board has an obligation to hear that recommendation and make a determination under Article or Section 170 within 30 days of the receipt of the report. And contrary to what the agenda says, we are not here to, I believe it says, adopt the recommendation.
It should be considered.
The statute says we have three options. Those options either to affirm the recommendation, to modify or disapprove them, or third, to direct under paragraph G that the matter be investigated further. There's a significant amount of information that's been sent to the board members since this by, I believe it's the counsel for the 5 chiefs that requested this hearing. Not only what was presented today, but there were legislative hearings on 2 bills that were presented that the state public defender appeared at. And I just want to read 3 things because I watched these, and anybody can watch these, but I watched them and I sent them to the board members. I'm sorry I didn't send them to you. I didn't know you were going to be appointed at the time. One is Mr. Starnes' statement in February of 2024 that there are roles for the Public Defender Board in Senate Bill 8, which subsequently became the law that created this board, particularly in regard to when contracts are not renewed, that is a role for the board. That was Mr. Starnes' statement. Representative Bacala, who provided many of the amendments to the original bill, this was in May of 2025, which would have been after this committee met, who said, quote, "What we did last year is we said, yes, we are going to allow these contracts to not renew when it's for good cause, and the appeal would be to the board that would be able to review, and I think we have some cases under review now." So clearly the legislative intent was for non-renewals to be a matter that had to be for just cause, in good faith, and subject to appeal to this board. Third, Representative Knox, also on that committee on May of 25, I believe it was May 8th, said, Mr. Starnes gave his word last year that all of the allegations you guys are making here today would never come to light. And yet you sit here today and it's almost exactly verbatim of how y'all forewarned this committee. And that was, he tried to terminate them by non-renewal. And finally, the vice chair of the committee, Representative LaFleur, said, I was making the same sort of observation that Representative Knox was making, and that is that Mr. Starnes is not in the room to defend his power grab because it is nothing more than that. I believe that had the committee had this legislative intent and this information to consider, that they would not have reached or should not have reached the conclusion that they did. And I will therefore make a substitute motion, assuming I'm not trying to cut anybody off from any additional discussion. But my motion would be that the recommendation of the committee should be sent back to be investigated further under the provision of paragraph G2. And that's my substitute motion.
I'll second that.
We have a substitute motion on the floor and a second. Any discussion on the substitute motion? All right, if nobody wants to address it, we will vote first on the substitute motion. Yeah, absolutely. Well, if you press it, I'll turn you on. Now you should be ready to go.
Thank you very much. And as the board knows, I'm brand new to this board. Could hardly find where the meeting room was this morning. But there is enough involved here that it makes it very, very difficult for me to vote intelligently on any of this. And I've got to support the motion because I think further investigation, at least from my point of view, as a brand new member of this board that knows nothing about what's happened until this morning, I would certainly benefit from a further investigation and additional knowledge. And I don't want to vote on something of this magnitude or importance without more knowledge and without more understanding. Thank you.
Anyone else?
I have a comment.
Yes, ma'am. Me?
There you go. I would say in further support of your comment that, by the way, I was on the committee and there were lots of substantive or supplemental material that was submitted after the hearing, which I would say we weren't able to consider. So I could definitely echo your sentiment on that.
Well, let me ask you a question. It wasn't submitted timely is why you couldn't consider it?
Well, I'll say first that...
I don't know. I wasn't there.
Right. I'll say first that I don't know what the consideration, what our obligation was to consider supplemental material. And I don't want to speak on behalf of the entire committee, but that was part of my concern, that we did have deadlines that were issued in terms of materials that should be submitted to be considered for the committee before the hearing. And so those things were submitted. There were supplemental things. There were things that were submitted timely, but then there were supplemental things that were submitted. And I don't recall us asking for any supplemental material. So, but I would defer to our committee chair.
I just want to make sure I understand, since I wasn't a member of the committee. You had a hearing. You gave deadlines to the parties to submit whatever they wanted to submit, and there were submissions. And you considered those. However, you received supplemental materials that were submitted after the deadline that the hearing had given to the parties to do so, correct?
Well, they were submitted after the hearing. But
after the hearing.
Yes, and I only make note of that because obviously they were sent to the whole board, but also to the respect that it could have resulted possibly in some different decision. So.
Any comment from the chair of the committee? Press your button and I'll turn you on, Paul. All right, now you should be on.
I'm on. Well, the committee made the decision right after we had our hearing. And it was based on what we had at that time. Personally, I don't like the decision, but I thought that was the decision that had to be made based on
What you had.
what we had. So.
Okay. Any other comment? All right, we'll vote on the substitute motion first. Mr. Huff, how do you vote on the substitute motion? Substitute motion is to send it for further investigation.
I'm opposed to it. I recommend, I'm sticking with the findings that were made by the board prior to my
All right.
entering.
Mr. Dwyer?
I support the substitute.
All right, we got one yes, one no. Judge DeMaia,
Yes,
in favor of the substitute motion?
right.
Ms. Boutte?
In favor.
Judge Katie?
In favor.
Judge Thaxton?
In favor.
Substitute motion passes. Now,
We have a vacancy.
well, that's what I'm fixing to address, the fact that we now have to send this for further investigation to the committee. We have a vacancy.
What about Mr. Thompson? He's still on the board, though.
Nope.
isn't he?
I received an email from him today resigning, a copy of an email to the governor that he sent out resigning, and so we're now going to have two vacancies on the committee. Which means we also have another board member that'll have to be replaced prior to whenever this comes back. But
I'll volunteer.
we, the committee, as I recall, was made up of Judge DeMaia, Ms. Boutte, and Judge Pitcher?
That's correct.
And Judge Gray.
And Judge Gray, I'm sorry, and Judge Gray. And Peter Thompson, that was 5. All right, so now we are going to need to replace 2 members of that committee, and I have Judge Katie volunteering, which is fine. I don't think anybody opposes Judge Katie serving. We're going to need one more member. Anybody from...
I would urge the 2. I know it might be a test by fire, but
that's why I'm looking that away.
You need 2, you need both of us?
I need 1.
I mean, I'll do it.
Mr. Dwyer throws his hat in the ring. All right, so just to recap then, the committee will now be composed of its chair, Judge DeMaia. It will have Judge Katie, Judge Gray, Ms. Boutte, and now Mr. Dwyer.
My question is, now, what is the charge for the committee?
Well, that's an excellent question, since we are on, as they say, virgin soil. As I appreciate what the motion was by Judge Thaxton, it was to utilize the option in the statute to send it for further investigation. I can only assume that means for the committee to convene and review whatever additional information is available from whatever sources are available to it. We were trying to accomplish all of this prior to the deadline of June 30th, and we sit here today on the 16th.
And, Mr. Chair, I want to make sure we don't get caught up in a time trap, because I don't think the statute provides for a timeline, if it is sent for reinvestigation, as to when that has to occur.
Well, considering the proposed termination of contract or non-renewal of contracts of June 30, I mean, do you really want to go beyond June 30? Because if you do, you have an issue of, do I have a contract or do I not have a contract? And I mean, as bad as any situation of losing a contract is for an individual, not knowing where you stand is worse. In my view.
Yes, sir.
So I would say that something has to be done as quickly as possible. Yeah.
My question, what do you want the committee to do?
To review any and all information that I guess you didn't review before.
If I might comment, I would suggest that it wouldn't be as big of a task as before. We don't have a need to have another hearing, in my opinion. And so
I agree.
It would simply be a matter of reviewing whatever supplemental written materials are submitted. We can allow for, if the state has additional supplemental material, I don't know, if the committee could decide to just give a short new deadline for additional material and then just review it on the papers that are submitted.
Well, let's do this. Let's set a deadline right now.
Well, the only question we have is it has to be subject to the open meetings law, and it has to be a public hearing.
I understand that.
As long as we comply with that.
I'm just saying, setting a deadline to receive the materials for the committee to receive it. That has nothing to do with the actual committee convening to review it. If we set a deadline of 7 days from today to receive,
Then doesn't the board then have to vote on that recommendation?
yes. But the deadline is 7 days from today for the committee to receive the information. Now, when the committee convenes to consider it is another date.
I think we should set now.
I agree.
Judge, one question, again, I'm not sure of the statutory authority of this board yet. That's my bad, being so new, but I couldn't avoid that. Do we have the authority as a board to extend the termination date that has previously been given from June 30 to maybe another 30 days?
Do not know that because this is, again, virgin soil. And the issue is whether or not there is already underway actions to replace those individuals or any of that. I don't know. Mr. Starnes, you want to
If I may,
address?
Mr. Chairman, my name is Ramey Starnes. I'm the state public defender. And I completely and unequivocally deny any of the allegations made against me regarding discrimination on any purpose, for any reason. Those statements were false, and I believe they knew them to be false. As far as statutory authority goes, Section 152B says the state public defender has the responsibility to ensure the statewide delivery of services for people accused of crimes who can't afford their lawyers, and must do so in a cost-effective manner. And B5 of that section says that the state public defender negotiates contracts. Those are solely the province of my responsibility. Non-renewed contracts. There's been a lot of loose language thrown out here today about terminations. No such terminations ever took place. They have a term. Term has expired.
He's going to argue his case.
I'm not, I've had to listen to you, sir, the entire
I'm going to
time.
allow him to address this board. This board has indicated they want all the information they can gather in order to make a decision.
And we voted, and there will be another opportunity for that, sir.
I'm going to let him address the board. We let everybody else address him. He's going to have his chance too.
I have non-renewed these contracts. The only authority for the renewal in the first place was a one-year provision that for automatic renewal for Section 161H1. That time limit has expired, and as of July 1st, I plan to move forward with interim district defenders in all of those vacant sections, and we're going to engage in the process for finding permanent district defenders in these sections.
Thank you, sir. All right. Now, back to Judge DeMaillet's request. You indicated you want to do something immediately.
Well, if we're going to do something, we need to do it immediately.
I agree.
And there needs to sign some contracts. We need people on,
I don't disagree with
He
you.
needs to know what he needs to do.
Well, One of the committee members is not present, and that is Judge Gray, but you do have a quorum of committee members present, so the committee could convene today to consider whatever.
That doesn't violate any open meeting?
No, I'm getting at that as far as you may have to have a meeting to, an open meeting to, I guess, express whatever, but I'm concerned that, you know,
Do we need to give notice for the meeting?
well, this is my concern. The board has voted to do something without considering all of what it takes to do what it's wanting to do. And it's kind of like sometimes the legislature does that. You know, it was quick to say we need to send this for further investigation without considering the fact that June 30th is 14 days away, and that the committee needs, if the committee is going to reconsider that, when is it going to do it? How does it impact the June 30th date? And that's something that we didn't discuss. We simply rushed to vote.
The option, one of the options is reinstatement. The statute clearly contemplates you go past some, quote, termination date, because one of the remedies is termination is to reinstate them with or without pay. So I don't know why we can't, I do believe we're bound by the open meetings law. We do have to give notice. It does have to meet all those requirements. But to say that with 7 days, I think we could probably get that notice out, number one. Number two, I do think we have to have an open meetings. It does say that meeting has to be public.
I agree with that.
Just because it's an investigation.
I don't disagree with the public meetings.
The concern I have, and I didn't make it clear to you, was I think the board would then have to meet within 30 days of that recommendation to vote on that. So I think that's the timeline. How soon you can meet, how soon we have to get back together to consider your recommendation.
Mr. Chair of the committee, what's your pleasure?
So I don't know about the other members of the committee, but I'm free to meet today, tomorrow, next week. You know,
Speak up.
the question is, do we need to give notice of the meeting, and how long,
We do.
how much
You do.
notice do we need to give? And
You have to give notice.
I'm willing to meet the first day we can meet under the law.
I'll say for the record, for our last committee meeting, we did give public notice, literally posted on the door of where the meeting was in compliance with the meetings. Couldn't find any other supportive platform to put that notice up. And then secondly, it was open to the public, obviously, as it was noticed. So we do the same process if we can't get it posted on the state's website.
Well, assuming you can make the decision of when you want to do it, we can provide notice immediately to the parties of when it's going to be, because they're here. And publicly, this is currently a public meeting. So if we provide notice in this open forum that this committee meeting is going to take place on a particular date, then I think we, at that point, have complied with the public meetings law, as long as it's done 48 hours in advance.
Sure. Even better. If we can have an opportunity to confer with each other to get a date.
Well, I tell you what we're going to do. We're going to take a 15-minute recess and let you all decide, because some of us have to potty.
Much appreciated. Right.
Dwyer. And these two.
I tried all those, and you don't have a website. I know, and the division administration never responded to my request, so that's why.
So just do the best.
Mr. Dwyer. Stephen. Mr. Dwyer.
Mr. Dwyer. During the legislative meeting.
I'm limping because I'm getting a hip replacement a week from today.
Oh,
Oh, my goodness.
I'm all right.
So we don't schedule our next meeting for next week.
My goodness. And it's a big joint.
Insurance community.
You go home saying, but you go home walking the same day.
It's amazing. My husband had both his knees done. He was walking around here.
I was recently chairman of Louisiana Housing Corporation, and I don't think we were allowed to have Zoom meetings. Does it allow us to do that?
There was something about that.
By making it easier for everyone?
Yeah, I can't remember. I mean, we did it last session. We definitely had.
The problem is how do you make it public, you know? Committee members can meet, how do you make it public?
We're just supposed to know everybody. If
Everybody.
yes.
Okay, did you know
post it. Like,
Okay.
where you can post it right down below for
I'll figure out how to do yours.
Some people could be there by Zoom. I mean, I'll go wherever.
Yeah, I think with the Zoom, the public, somebody has to go on vacation when the public is there. I mean,
I can get the board, Blackhead Bar Association board for everybody. But I don't know if y'all want to be there or you want to be here, wherever you want to be.
When I love just every year or two, it's like we got the power to extend services.
Yeah.
Why is it not
He's against it. But he's against everything that has come up, so I don't know.
We need a lawyer to advise.
A real lawyer. Real lawyers, judges don't know, right?
He won't cooperate. That time I got that on the radio, it was 10 miles.
Yeah.
Delay.
Hard to
He
believe.
kind of
Hard to
zoomed
believe.
non-cooperation.
You know, when you're
Think about what you're saying now.
Hey,
Couldn't think before.
I'm sorry.
Couldn't.
I'm sorry.
Got too excited in here for you?
You know,
Y'all keep taking. What a great way to start.
Hey, how are you?
he paid me to come out around and stare at me. But you felt it too. That's my husband. Okay. Yeah, last week
Are we in the same clothes?
So, this one, I don't do any civil work, because I have parallel cases with it. And what happens is that, the day before the hearing, you get a stack of stuff that you're supposed to read. I think civil lawyers are approval with each other, the problem with this job.
Yeah.
He's being appointed to the
I think it's great.
All right, what kind of dates?
I can,
I'll make time whenever.
this is,
Later this week is better for me because of the surgery I got on
Well,
Monday.
the thing is, this meeting we're gonna have has to be a public meeting, it has to be noticed.
48 hours.
24 hours.
Right, so we'll give notice before the next meeting.
I don't know if we're waiting for the public meeting, but
Yeah, no, that's what the chairman was saying. We reached the dates now, in case the announcement today.
We'll be able to get people 7 days though.
I don't think that week's like.
The information's already in. That's right.
And if there's Thanksgiving on the first day.
I've never seen the chairman of the committee who voted for something rescind his vote at the next meeting. I appreciate that. No, I appreciate it.
Open-minded.
That's what makes me realize. So, just get a badge of honor. In my vote.
How about Thursday? That's the 10th. Or the 19th. Is that a real? Oh, okay.
Yeah, the council just reminded me that, so I think that means that they're closed out.
The 20th?
That's Friday, so what would we consider?
18th is good.
I got some.
Meeting was scheduled for the
For the 18th.
I still have it on it.
Well, at least you got it blocked off, so you're good. But I'm very serious, thank you for speaking out. No, really.
It's amazing.
You know, Brad, what am I supposed to do? And then, you know, when I heard you give your opinion, I said, well, what I got to do here? So I really have to like you.
Strong, courageous.
It is.
Yeah.
Imagine that.
It's always a trial by fire when you join the board. See, when I came in, it was like a little flurry. Okay, so.
Most convenient for me, but.
I got to drive anyway. I don't
Where
care.
are you?
I'm in New Orleans. I got to drive anyway.
I know, but a place for a meeting.
It's only just a small.
Capitol's okay. It's open on the 18th.
What?
Capitol's open. House is not.
So you can just let us know. I don't mind driving here.
We do it.
Do a notice.
Today, on camera, and it's recorded. And I think that's it. I think that we put it on record.
Do we have an assistant AG that assists us? No?
We have that. So, the 18th is the deadline.
We're exploring all of that out to deal. And you can tell them, so this would
We have to give them a deadline to submit.
What is it? And it's them submitting them?
Whoever.
Why don't we just,
Well, he's actually.
so we have 18?
The shortest period of time.
Oh, no, 48 hours. We have to have it.
Oh, okay. Because I'm sure they have all the material.
One of the meetings, let it be Wednesday, we gotta get willing to give them 24 hours to present additional.
Job performance.
And that's just to submit the material. But that's
Meeting in August. You're talking about having a meeting on the 18th?
Right.
One Wednesday. Submit the materials.
Tomorrow, somebody's gonna complain about that.
Absolutely.
Who's going to complain? They-
Well, I mean,
You think he'll complain? He doesn't submit anything.
submit.
Not a whole lot.
And I think some of it is the legislative history, so we review that now.
Yeah. All right, so the 18th.
Can we make it in the meeting at 8:30? Then they would have.
Like 3 o'clock.
Actually, 5 o'clock.
You know what? Serious black lawyers. That would be
24 hours. Today. For Wednesday. Okay. Can we get one of these rooms and put that on the notice? I'll ask them. And on the
Even though it's your website.
We said 3 o'clock?
Yeah, 3 o'clock on Wednesday, and I'm gonna reach out to Ann too, 'cause I'm gonna call her. Okay, all right. 18th at 3 o'clock. No, that's good. And so we come here. Recording it.
I mean, separately, yes.
Judge Kitchen, no, Judge Ray may be in, yeah. Well, the 18th, no, she had a doctor's appointment on the 18th. You have been working outside.
You have that Cajun blood. They can't.
Summertime.
Yeah.
And I worked at.
And you walked barefooted everywhere. I know that.
No. Shoes to church.
Oh, yeah.
Oh, goodness.
Oh, tar. The black tar.
Yes.
I did too, but my husband worked on Shell Road. They had shells on the driveway. Said he didn't have any shoes and ran on the Shell Road.
You get desensitized.
I was a city girl.
Yeah, right. Rub it up for you.
3 o'clock.
Testimony, we want to get back to entertainment.
What y'all had was the speaker. We have to call the speaker? Who's the speaker? Who is the speaker?
DeVilliers.
DeVilliers.
Right.
Yeah. To get one of these rooms.
Yeah, to reserve, yes.
No, we don't.
We have to get permission for one of these rooms.
We can get that from the speaker. That ain't a problem. Speaker's office will give it to us.
Okay.
If not, I'll call the speaker.
Oh, you gonna take care of it?
But I mean, I'll talk to Stephanie in the speaker's office. We can get it. That's not a problem. If it ain't this room, we'll get one on this hall, so it won't be a problem.
We need a clear understanding of what we're gonna do.
Yes, we do. I agree with that.
Committee, I think we decide that,
What?
what we're gonna cover at the hearing.
We can cover one of the things is the AG's opinion, and then the extra materials. It would be the legislative history that came up during the legislation meeting last week, 2 weeks ago. I watched it too. It's hard to believe.
What do we ask you?
I know, I think we have to do that, we have to decide that amongst the committee. And so we had to reach out to Judge Bray too, so we can have a meeting real quick on the phone or something to determine what gets considered, would be my suggestion. And not have the board decide that, that's a committee.
I think what we do is we'll take the recommendation and kind of dissect it and see if that's your recommendation was what the AG opinion was.
Basically reconsidering.
Yes.
Well,
And reconsidering.
only in light of the new information, right?
Yeah, giving it more information. Consideration. I think you can overturn with a recommendation.
I'm going.
The surf and the honeypots on the Holy Grail when they throw it out of the party. I'm not dead yet. I'm not dead yet. Wasn't very good example.
We all had general sentiments.
We all had one.
We all had general sentiment that he did.
Yeah.
It just was what it was.
Yeah. And that's how I read it. That's how I read your recommendation. It was what
Okay,
it was.
we got everybody in? Let's reconvene.
I think we can reconsider, and it doesn't have to be the same recommendation. That's what I thought was Judge Jackson's.
With the new information that we did not.
All right, let's come to order. All right, the committee's had a chance to speak to determine what deadlines will be set. Judge DeMaya, have y'all come up with anything?
The committee decided to meet, you'll correct me if I got it wrong, on Wednesday, June 18th at 3 p.m. here at the state capitol, but more,
As of right now, it'll be this room. However, in the event that we find out that this room is not available, this room will have a notice posted on the outside door telling you where to go. How's that for clarity?
okay. And
And I'll get with the speaker's office to make sure that we have a room available.
okay, and the purpose of the meeting,
To reconsider new material.
to receive new material. to be considered in whether or not to change the recommendation that was previously made.
My understanding of the law says you sending it for further investigation. So at that point, you're opening it up to considering additional material other than what was considered at your original meeting. And then the board will have a recommendation, whatever that might, the committee will have a recommendation, whatever that might be, after consideration of any and all materials submitted. Do you have a deadline for the submission of materials?
The 18th.
The 18th?
The 18th.
Let's just say, can we just say 9 o'clock that day? So just in case it's something that takes a little time to review.
All right, so the actual meeting will be scheduled for June 18th at 3 p.m. Any and all materials that each side wishes the committee to consider that has not previously been submitted shall be submitted by Wednesday, June 18th at 9 a.m. to the committee members. All right?
Now, the question
Yes?
is, how are they going to know how to get it to the committee members?
Well, that's
We'll send an
excellent.
email out, like we did last time. You send an email out with all the contact information.
Okay.
The committee will send an email out to all concerned parties on giving email information of the members. All right? Are we done with item 7 for today? Okay, let's move to item 8. Contracts. Mr. Starnes?
Mr. Chairman, members, about all the contracts, the district defender contracts have been sent out, and they have been agreed to, I believe, by all 30 district defenders that I'm offering contracts to. These contract provisions call for very similar terms to what has been typically been done, the 12-page contract, with the exception of the waiver of Section 161 H1 and H2, the waiver of the Section 170 proceedings not relevant to actual terminations or demotions. There is a 30-day notice for termination by either side. And again, I think all 30 district defenders have agreed to that and to take effect July the 1st. And my compensation plan, the compensation plan that the office developed. So and I think those were 27 signatories to that email y'all got referenced that. And we plan to go forward July 1st with those contracts. I also plan to select interims. I've been working on that. Also ready to go July the 1st. They'll have their own contracts just for the interim period. About contract programs over 250 that require the board's approval, there needs to be several items that we discuss. The first of which, we're statutorily obligated to contract with ULM, University of Louisiana Monroe. We've done that, and that contract is less than $250,000. We have not renewed a contract with the Innocence Project in New Orleans. However, I do believe they're going to contract with a district. And we did not renew a contract with the LAP program. The LAP program is the outside law firm that we previously contracted to do direct non-capital appeals. That program was innovated by a man named Jim Looney, who retired some years ago and recently passed away. It's been led by a man named Chris Aberly, who's planning on retiring this year. I searched and looked around for options to keep that program going. I couldn't find an acceptable one. So what I'm doing is we're just going to do the administration portion out of my office, contract with lawyers to do writs and appeals, not just appeals, around the state of Louisiana. Typically, there's about 400 direct appeals. We'll contract with sufficient lawyers to do those. RITS, that program's still growing. I think we took 67 last year. I'd like to see a lot more than that done, and we'll have lawyers who can take writ applications as well. I wanted to start that July the 1st, but my deputy, Mike Mitchell, is going to run that, oversee that organization. He's recently returned from an extended absence, and we spoke with Chris Aberly last week about extending the LAT program by 2 months. So we plan on implementing this September the 1st. That won't be a contract over $250,000 that requires this board's approval. Also, we have the capital programs. As you know, a few years ago, we merged the Baton Rouge Capital Conflict Office with the 19th Public Defender's Office, and Kyler Romanak oversees that one. This year, we're going to fold the Capital Defense Project of Southeastern Louisiana into the 19th as well, and have Kyla oversee that. Those monies to pay for these programs will come through my office. I'll send to the districts, and the districts will contract with the people necessary to do it. The Attorney General has issued an opinion about that. That arrangement doesn't require this board's approval. And that AG's opinion is in your packet. The outside programs that do require your approval are all capital. The first is the Louisiana Crisis Assistance Center, LCAC, which is the third trial level program. It's the one outside remaining program. They have just like the Capital Defense Project of Southeast Louisiana and Baton Rouge Capital Conflict Office, they're part of our statewide network that take capital appointments and try all the capital cases, litigate all the capital cases in Louisiana. They're a necessary part of the capacity, what limited capacity we do have to litigate capital cases at the trial level. And so I recommend the renewal of that contract at $1,390,000, which is the same amount it's been for several years. The other two are post-conviction and direct appeal programs, one of which is one we merged last year with the Loyola Law School to do capital direct appeals and some portion of the post-conviction load in capital cases. I think they have 9 post-conviction cases. That amount is $1,050,000. The third program is known as Mwalimu Center for Justice. They have the other 31 post-conviction, capital post-conviction people in Louisiana, and we recommend the renewal of their contract at $1,265,035. That sounds like a lot of money because it is, but we don't have the capacity to defend capital cases in any other way. There's been recent legislation that is changing some of the timelines and requirements in capital post-conviction that's going to require even more intense effort in the coming year or so. The legislature has allocated over $4 million for these increased costs, but it's not money that comes directly to the public defender system. To access it, we get approval through the Joint Legislative Committee on the Budget, and through a new procedure they developed to do that. So we'll get some money, I guess, when needed or as appropriate. We haven't gone through that process yet. The language of that statute and relative to funding for public defense is a little tricky. I think they were trying to assuage some concerns in Louisiana, in our public defender system. A dollar isn't necessarily a dollar. We have a statutory requirement that 75% of all the money that comes to the public defender's office goes to the districts, and either through the annual budget or through the public defender fund. They also have the money coming from somewhere other than state general fund. So I think that was an effort to kind of get around that. I don't think it does. I still think the 75-25 rule is applicable, and that makes it very difficult to contract with outside of the 75%. That has to go to the districts. But some of these things were done in an effort to address those concerns. But I ask for the board's approval on those 3 contracts.
So you need action.
Yes, sir.
All right, anybody prepared to make a motion to approve those contracts? Got a motion and a second on the floor to approve all 3 contracts.
Are we going to take these up in order, or are we going to take the contracts in D? A, B, and C, I think, need to be talked about first. Or we can approve these contracts and then talk about them, but I don't want to skip over.
We're not going to skip them.
Thank you.
All right, so we have a motion and a second to approve the 3 contracts requested by the Office of the State Public Defender. Any opposition? Hearing none. Motion is approved. Those 3 contracts are approved, and I'll execute the appropriate resolutions required showing that we approved them at this meeting.
For the record, I abstain. I did not have opposition, but I do abstain.
All right, we have 1 abstention.
Thank you, Mr. Chairman.
Now, let's go back and discuss items 8A, B, that Judge Thaxton was requesting.
Yes. As I alluded to, all 30 of those contracts have been agreed to by the district defenders. They include the district defender compensation plan that I developed, my office developed, and they waive any requirement that this board set the district defender compensation plan. Like I said before, I have a statutory obligation to establish and maintain in a cost-effective manner delivery of legal services, and I negotiate contracts. Those are 2 very explicit grants of authority to the state public defender. I take them very seriously. I think the district defender compensation plan and all of its elements proposed by the Oversight Board would violate those principles. I'm not going to have contracts that have those provisions in them. That's why they were waived. They were waived in District 8 and District 27 contracts of last fiscal year going forward, because I knew we were going to waive them going forward in the fiscal year 26 and beyond. We renewed the contracts because the statute said that if you had a contract in place for fiscal year 24, then it carried over into fiscal year 25. District 8 and District 27 were 2 districts where we replaced district defenders in the middle of the year, so that requirement wasn't there. So when I issued new contracts, it was consistent with what the contracts are for everyone else in fiscal year 26. As I mentioned before, the contract provision that applies to Section 161, H1 and H2, was only for 1 year, and that's explicit in the legislation. So as a result of my authority to negotiate contracts, which also includes the authority to negotiate to contract with whom I choose, we have completed those contracts. They're ready to go forward July 1st, 2025.
Chair, are we done with Mr. Starnes? I'd like to have a conversation among the board members.
If you have comments concerning that item, feel free.
I do, but my question is, are we done with Mr. Starnes so he can stand down?
Well, I don't know if anybody's going to want to address a comment to him.
Back up. I'm not going to have him sit there and point his finger at me anymore. So I will go ahead and.
I think Mr. Starnes can sit there. I'll turn his mic off until such time as I turn it back on.
All right. Let's start with this. 161H2. The office. Sorry.
Hit your butt.
I'm not going to touch it.
Now you're on.
The office shall set the compensation of each district defender according to a compensation plan established by the board. That's the law. At our June 12, 2024 meeting, a motion was made which the chair clarified that we continue the current compensation plan as provided for by statute by the chief, and that we continue the hiring of the vacancy which is in the 8th. We had a compensation plan on that date. We agreed to continue it. We specifically provided that it would be used in filling the vacancy in the 8th. That's the law. That was the motion that was passed by this board unanimously. And 2 months after that, Mr. Starnes did not apply the law, and he ignored the motion that was approved unanimously by this board. Now, he argues today that he got these chiefs, not only in the 8th and the 27th last year, but for this year, to waive not only the compensation plan that we approved, to basically cut us out when we have the statutory duty to set that, and he has the statutory duty to use it. He says they waived it. I'm not going to argue that they can't waive it, but I will suggest to you that he can't waive it. It's the law. It's his obligation. That's number one. He has included that in his new contracts that these chiefs have signed. And I want to read to you, and I've received a number of phone calls, but I want to read to you this confidential email that I received. I do not understand how a state employee, the public defender, can lawfully require that an independent contractor waive their statutory rights and protections as a prerequisite for contracting with the state of Louisiana. If district defenders could express their opinions with complete anonymity, I do not believe they would agree with this policy. However, all of the district defenders are aware that their contracts may now be terminated in 30 days by the state public defender without cause and without appeal. The district defenders are afraid to even discuss this among themselves due to a well-grounded fear of immediate termination if their opinions get back to the state public defender. We have no protection at all other than the board. The overwhelming mood is fear. I am even afraid to send this message. Please help us. That's the environment that has been created. And I reiterate, his duty to include our compensation plan in this contract, in the 8th, the 27th, and every one of these that he's already signed, is shall. He cannot waive shall. That is a legislative mandate. That's my point to the board. And I'm not asking for a debate. I put it on here that everyone would know about it.
Thank you. Anything else you want to address?
I'm done.
Okay.
I am done.
All right. Your last thing that has not been addressed on the agenda is number 9, the legislative update.
I provided copies of that information to the board. Again, I apologize to the 2 new members. These are 2 bills that were introduced. I think if you talk to the legislators who brought these bills, they'd be glad to tell you who was behind them. They basically stripped this board of its authority other than for contracts over $250,000, which we've now basically funneled through the districts, so we don't have those anymore, several of them. And it did away with this board. It created an advisory board that had one function, contracts over $250,000. It took away the supervision and oversight of the state public defender. And at the hearing, the legislators were so distressed that we have now had in 5 years 3 attempts to abolish boards, all of which Mr. Starnes had come and testified for. He provided a white card. That the authors actually apologized for the bills. I just want to make you aware that we sat here in March. Those bills were then filed. He didn't tell us about it. We didn't know about it. And if we hadn't been paying attention, and if those chiefs that he's now non-renewed hadn't gone and testified, we wouldn't be here today. I just want to make you aware of what the climate is out there. Third time, 5 years. Thank you.
If I may, Mr. Chairman,
Yes, sir.
those bills were largely cleanup bills. There's archaic language and confusing language go back several boards ago. The provisions about moving the board out of the office to its own board, its own section in the statute was well necessary. I think that y'all sit here today and we see now how difficult it is for this board to actually deal with the public defender system. I don't have to say anything other than look at what's happened here today, and you see a lot of the problems and a lot of the confusion and a lot of the confusion about what everyone's role is. I know that there's some retired judges on here, and I know that's a valuable perspective, one I certainly don't have. And I think there's a lot of good that can be done from that perspective. But this is an executive branch board. It's not a court of appeal. And the role, and I think the reason for some of the shared responsibilities is for collaboration between me and my office and you with your unique and valuable perspectives. We've never had that. In the year and a few months of this board's existence, we haven't spoken about the 146,000 people who need public defenders to represent them in court every day. We haven't talked about the difficulty in finding new and more and well-trained public defenders to represent those people, or how to have find a funding source that is renewable, sustainable, and reliable to keep a public defender system statewide solvent. We haven't discussed that one time. We've been sidetracked by unnecessary frustrations regarding the non-renewal of contracts, which I firmly believe to be absolutely necessary to make the system as good as it can be, make the 146,000 people that we have proud to have public defenders standing up for them. This is the direction we need to go. It's hard to do it with people who don't have the same goals that I do, that we should all have, in my view. So, to the extent that the legislation was proposed, I support that. And next year, I'm going to probably ask more legislation be proposed because the statute still isn't where it should be. Language still needs to be cleaned up. One of the provisions in the bill was to grant statutory immunity to members of this board, which currently y'all don't have. So it's more complicated than that. It's not going to work well between the public defenders and this board if some people choose to drive their own agendas or try to thwart progress. That's just not how this is supposed to be set up. It's supposed to be collaborative. I've always offered myself to visit with any of you about anything, provide any materials. That offer still stands. I've met with many of you one-on-one. I'll do it again. I'll go to where you are at any time. But my focus is, and has always been, on having a statewide public defender system that defends the people accused of crimes to the best of our abilities and get the best results we possibly can. And I know to do that we need a funding source and we need to get more lawyers involved. We need to train them up and resource them well. And I do that. I work on that every single day. I'm not going to be deterred. And again, I plan on moving forward July 1st with interims in those 5 districts and the contracts that we have. I do agree 100% that it's simple contract law. They can waive those provisions. I can't. That's why I've asked that the board adopt the compensation plan that we came up with to make it include the District 8 and District 27 of the fiscal year 25, because you need to do that. There is no temporal element to when those approvals need to be made. So I'm going to ask at the next time we gather for the same thing. I'm going to keep asking for it till we get it. With that, Mr. Chairman, I thank you.
Thank you.
Mr. Chair, I have one comment, then I want to
Press your button and I'll turn you red.
never know whether to go first or second.
There you go.
I agree with much of what he said. The source of the chaos and the distraction is Mr. Starnes. It was with the last board that he abolished, and it has been with this board. And with that, I'll make a motion to adjourn.
Wait, yeah, I have a comment.
Press your button so I can, once you press it, then I press it and you
I'll
are
press on.
eliminated.
Okay. I took a little offense to some of the comments, but I'll say this may be the contracts, for example, with the public defenders, particularly the ones that have recently been submitted for consideration. It may be a contract law issue in terms of whether or not a party can choose to waive something, but it's clearly stated that the compensation is based on the public defender's compensation plan. That plan, as Mr. Starnes just reiterated, has never been approved by this board. How can it be used as a basis for compensation if it's never been approved? And if it's an irrelevant point as to it being approved, why is it still continuing to be put on the agenda? Obviously, it needs to be approved by this board. It's our authority to approve, not the compensation plan, but it's our authority to approve a compensation plan. It has already been approved. There is one that's in existence, and that has been continuously been ignored, and it's very clearly stated in these contracts that it is not being considered, it's not being applied, and it's not being referenced as part of the contract. That's a statutory violation. And I know this board has been stripped of a lot of power. It's very frustrating for me personally when we are kind of having a roundabout conversation about this over and over again, the same thing. And we've kind of just glazed over the fact that these contracts, the two that are in the packet today for consideration, have not yielded or any sort of consideration to the compensation plan that is already in place. In fact, it completely is in violation of it. That's a problem for me, and I don't have the answer, unfortunately, as to what is the move that can be done, other than the fact that in the past, for sure, the board has had to vote on whether or not these contracts should be, and today, should be accepted. We've moved over that. We haven't even asked for a vote on these two contracts for District 8 and 27 as to whether or not they should be accepted as proposed or renewed as submitted.
We don't have the authority to address those contracts. They're under 250.
That's a recommendation from the Attorney General. But it's still violating something that we've already passed. That's law.
I understand. It's just not before us.
Yes, I have.
Hang on, let me. Go ahead. Now you're red. Once your mic is red, you can speak.
Okay. I volunteered to be on the compensation committee. I don't know what happened other than we presented our recommendation and it's not being followed. Now I've volunteered to be on another committee. I'd just like to know that it's relevant that I meet. We met several times publicly. We had public meetings, and we had several meetings. Persons came from all over the state for the compensation committee meeting, and that's just, we just move that forward. But I agree with Adresia. We keep doing the work. We haven't had And Mr. Stern said he has problems, getting, he has to have well-trained people. Well, I see well-trained people working as public defenders. And I don't understand how you can rid yourself or rid the state of well-trained people without a basis for ridding them. We've asked several times and we haven't gotten an answer. I mean, I think that it's in the clouds somewhere. But I'm a little concerned because we've lost 2 members because of the chaos. And, life goes on. For the rest of us, we're here. We're going to keep plowing through what's there. But I think that one of the things Mr. Stern said that was truthful is there hasn't been any collaboration. And I don't know where the basis for the lack of collaboration is, other than the questions haven't been answered. Why are these people being non-renewed? We've asked, but no answer has ever come up. So I don't understand what we're doing. But I also want to say that we have to have another meeting of the board before the end of before the end of June. The committee met, just, has decided on a date. It's June 18th, we're going to meet. But after we make our recommendation, which will probably be that day, we need to have another meeting of the board before the end of the month. So we can't adjourn until we figure that out, too. That's it.
When do y'all want to do it?
How about the next Wednesday? Or every Wednesday, or Monday?
Well, if you want my participation, it has to be before the 25th.
Okay.
I'm leaving on a trip from the 25th through July 5th.
How about the 23rd?
That's a Monday.
Yeah.
Could we please have it at 1:30 or 1 o'clock in the afternoon?
The only reason I didn't do today's in the afternoon, so that you'll know, I was having a discussion with you during our break, that I have to be back for some pre-op stuff this afternoon for the procedure I'm having in the morning, which is why we moved it from the Wednesday to today. My fault. I'm getting old. Things are falling apart. All right, let's look at a calendar. Monday the 23rd. Do we have a quorum available for Monday the 23rd?
It's in the afternoon. You can do that 1 o'clock.
Or 1:30, whatever is best.
Not 9 or 10.
Okay. Paul?
That's clear with me, but what are we doing on that day?
We're meeting to consider the committee's recommendation that y'all going to do on the 18th.
Okay.
I'm available.
Okay? Do we
Nice.
have a quorum?
1:30?
1:30?
I can do it. 1:30 to 23rd.
Mr. Chairman, I won't be able to make that, but it should go on anyway.
Well, we'll have a quorum if we have 1, 2, 3, 4, 5, 6 of us available. That's a quorum.
And he's on the committee, so.
Yeah, he'll,
I would have participated on the 18th.
correct.
Like you, I'm having a surgery in the foot.
Good luck.
Just a little hip replacement.
Just a little hip replacement. Mine's not quite that big, thank God. All right, 1:30 on the 23rd. Putting it in my calendar right now. Well, all right. Are we ready to adjourn? We got a motion. Any opposition? Got a second?
Second.
All right. We're adjourned.
Thanks, Chief.